This is file 23-2155 FH or FYI.
Okay, so Ms. Trask, are you still there?
Yes.
All right. So this is a probation violation hearing. Mr. Elhart, you've been retained now to represent Mr. Foz. Are you prepared to go forward with the hearing this morning?
Yes, sure.
Okay, so Ms. Traska, if you could please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth? So help you God.
I do.
All right, and if you could please start by telling us your name and how you're employed.
Amanda Traska, probation officer for Leelanau County with District Court.
Hang on just a moment, Mr. Elhart.
If I may, Your Honor, Mr. Foz is here to admit that he is unable to do the community service work.
Okay, so he wants to enter a plea.
Yes, Your Honor.
What about the added violations for, let's see, failed to continue counseling with the cancer center, disrespectful of court employees and care providers, and acting in a threat, intimidating, harassing manner. Okay, so then, Mr. Foz, is that correct? You're changing your plea in this case to guilty of the violations. That's what you want to do, is plead guilty.
That's his direction, yes, sir.
Okay, so it's still your decision, but I understand you've consulted with Mr. Elhart, and that's what you've decided to do.
Yes, sir.
Okay, so before I take your plea, I want to make sure you understand that you do have a right to a hearing at which Mr. Elhart would represent you, and you're choosing to waive that right, correct?
Yes.
You also understand that the worst that could happen is for this conviction of leaving an accident causing injury is you could be sentenced to up to a year in jail.
I don't understand that. I thought we'd already been through that.
Before we even get into the courtroom audio, let's set the stage here, because this case is a masterclass in entitlement colliding with reality. What you're about to watch is not just a probation violation hearing, it's the unraveling of a man who genuinely believes the rules don't apply to him. This defendant wasn't some helpless victim caught in a misunderstanding. He was convicted of using his truck as a weapon after feeling disrespected by cyclists. And instead of taking responsibility, he spent every step of this process blaming literally everyone else, the victims, the court, probation, medical providers, anyone except himself. Now here's the twist. The court already gave him a massive break. Because of serious medical conditions, he avoided jail and was given probation with alternatives. And what did he do with that mercy? He ignored court orders, failed to complete community service, stopped counseling, sent hostile communications, and allegedly threatened court staff. This hearing isn't about sympathy, it's about consequences. And as you'll see, the judge is about to peel back every excuse, every contradiction, and every ounce of self-pity. Stick around, because the longer this goes on, the worse it gets for him.
Well, that's the worst thing that could happen. Do you want to talk to your attorney some more about that?
By violating probation, the worst thing that happened is the maximum.
Okay, so you understand that, correct? Okay. Has Mr. Elhart answered all of your questions to your satisfaction?
Yes.
And no one's used any force, threats, coercion, or made any promises to you to get you to waive your right to a hearing this morning, have they?
I'm going to say no, sir.
All right. Then the report indicates you were placed on probation back in October of 2023 for leaving the scene of an accident causing an injury. And as a condition of that probation, you were to complete 30 days of community service work within the first 180 days. Is that true?
Yes,
And the fact is you did not complete the 30 days and the 180 days, correct? There's also an allegation that you failed to continue your counseling with the Cancer Center as ordered. Is that true?
true with extenuating circumstances. It's not true that I refuse or I'm not doing it. As I've mentioned before, a letter was sent from the parole office without my permission or knowledge to my medical providers asking for information on my medical records. When I found out about that, I called my medical provider. They said they deleted the email. Right, this went on for about 3 months, me trying to get the email from my provider. She went to legally refused. And because of that letter that was written by the probation department and my asking about it, they discontinued service. They refused service because they didn't want to get involved in a legal case. I also went to my
Okay, so I'm going to give you and Mr. Elhart a full opportunity to explain the circumstances of these violations. But for right now, I'm just trying to establish if you're pleading guilty to this. For whatever reason, you did not complete the counseling that was ordered through Cowell Cancer Center, correct?
correct, but not due to my circumstance, due to their circumstance.
Answer is yes.
Yes, sir.
Okay. So, is it also true you were disrespectful to court employees and or service or care providers?
I was honest with them.
Okay, but would you agree that you were disrespectful to them?
To me, sir, that's a very subjective term.
Well, we can have a hearing on that issue. We can
Well-
have Ms. Traska go through all of the emails and other correspondence.
I've got them too. I've got them here as well. And if you mean saying, fuck you and the horse you rode in on for writing that letter and other things like that, yes, I did.
Okay,
If you call that disrespectful, yes, that was disrespectful.
all right. So, and then it also, the allegations are also that you acted in a threatening, intimidating, and harassing manner towards other persons. Is that true?
No, sir.
This is a critical moment right here, and a lot of defendants try to play this exact game. Notice how he suddenly claims he doesn't understand the possible jail sentence. That's not confusion, that's selective memory. The judge calmly explains something very simple. Probation is not freedom, it's conditional mercy. When you violate probation, you don't reset the clock, you reopen the door to the original punishment. And here, that means up to a year in jail. What's especially telling is how his attorney understands perfectly, but the defendant resists hearing it. That's a pattern we'll see again and again. Whenever the facts don't favor him, he suddenly becomes confused, overwhelmed, or victimized. Judges see this daily, and that's why the court goes step by step, locking in the record. This isn't about tricking him, it's about making sure he can't later claim he didn't know what he was risking. And trust me, that clarification is going to matter later.
Yeah.
For the purposes of this hearing, I suggest we go with the two that he's admitted to, and you can take into account whether or not you think the fourth is appropriate to consider for any sentence.
All right. So, Mr. Elhart, are you okay with that?
I am your.
All right. So then, Mr. Foss, to the first three allegations, how do you plead?
Yes.
Guilty.
I'll accept your plea, find it is voluntary, accurate, and understanding. And Mr. Elhart, what else would you like me to know?
Thank you, Your Honor. I'm in the sentencing phase now, Your Honor.
Yes.
Thank you. Your Honor, Mr. Foz was, and you had received it, I think, a copy of a letter dated nearly a year ago where he was given 2 years to live. He may not make it to his next birthday. He's under daily chemotherapy. Cancer has spread to his bones, the rest of his body, and the liver is at lymph nodes. I'm sure that he's undergone great deal of modifications to his temperament, the way he behaves, and to everything else due to the cancer. I'm very certain in looking at his history and talking to him about his history, what he's done for our country, that he was an exemplary citizen. Cancer has changed who he is and what he is doing. His behavior many times inappropriate. Certainly, I understand his dismay that his medical rights were violated. By the same token, I understand what was going on. He can't do any work of any kind. He can barely make it here today.
Mr. Alhart, are you aware that he was given the opportunity to consult with the probation agent to try to come up with non-physical activities that would count as community service work, such as writing letters to veterans?
I wasn't aware of that.
I wasn't aware of that either, man. That's never been proposed to me.
Right here in open court. Okay, go ahead, Mr. Alhart.
What was right here in court, Your Honor?
When we were here on the first probation violation. Okay, thank you. Mr. Foss, is there anything you'd like to add?
Yeah, there's a lot that I'd like to add, Your Honor, but it doesn't really pertain to what we're doing here today. I've been really disappointed by the professionalism exhibited by the probation department, my violation of my rights. The scales of justice don't seem to be equal. Inflammatory language, refuses, inflammatory language like that. It's not accurate. It's not true. I never acted in a threatening, intimidating manner. What I do demand is service from my public employees, and refusal of service is unacceptable to me. And that has happened with probation and not probation with my FOIA requests.
Now we're getting into the heart of the excuse machine. The community service requirement was crystal clear, 30 days within 180 days. No loopholes. No ambiguity. And instead of completing it or formally requesting modifications with documentation, he simply didn't do it. Then comes the medical explanation, but notice what's missing: verified compliance, proactive cooperation, or even basic follow-through. Here's the key legal issue people miss: having medical problems doesn't automatically excuse probation conditions. You still have a responsibility to communicate, document, and work with probation in good faith. Courts bend when defendants show effort. What they don't tolerate is defiance disguised as helplessness. And as this unfolds, you can feel the judge starting to separate legitimate hardship from outright refusal. This isn't about whether he's sick, it's about whether he acted responsibly. And so far, the answer is not looking good.
And when I receive pushback like that, I don't think I've made any unrealistic requests. I'm not familiar with how the legal system works, but when I am refused service, it makes me a little irritated. I expect professionalism from my public employees, and I admit I've not been professional. I've been irate, and I get that way very easily. Part of it's, as we mentioned before, testosterone has a huge impact on that. It changes your personality. I had a doctor's appointment last week, and I mentioned that to my doctor, and he said it's an effect of testosterone. And the reason I'm unable to perform these tasks is because of my testosterone levels, my chemotherapy, my sicknesses. The reason I missed my last appointment for probation, and I mentioned this to Ms. Trask, I wrote her a letter. I'm very sorry I missed the appointment. I was ill. I don't get my mail every week. I apologized, and I asked her if there was something I could do to mitigate the situation. I never received a reply. So it's not that I'm fighting and refusing to do what you're asking me to do. I will happily do, if I could, sir, I would happily do what you asked me to do, but I'm not physically able to do it. I've mentioned that I would be happy to pay a fine to help out the community, but physical activity service, yeah, I'm not able to do it.
All right. Mr. Chamberlain, anything for the people?
Your Honor, I agree with Mr. Foz that the scales of justice are not equal in this case because he was charged with a felony and could have been charged with 2 others for felonious assault. Your Honor, he got mad at someone who flipped him off. He turned around, drove his vehicle right at them, slammed on the brakes, and one of the people got hit. That person was in the hospital. They had their leg split open for, I believe it was 4 days with a pressure bandage. So from about the top of the knee to about the top of the thigh. And that was due to his actions, due to, as he said, his anger. Mr. Elhart said, cancer has changed him. Well, then that means he's a public safety risk. Your Honor, because I ran the guidelines in this case, and had he been convicted of just what was on here, he's looking at 0 to 14 months. Had we increased it to the 2 additional felonious assaults, it would be 7 to 23 months. That's OV1 for using a vehicle as a weapon, OV2 for the potential lethality of the weapon used, OV3 25 points for life-threatening and permanent and/or permanent incapacitating impairment. OV4 10 points, serious psychological, requiring therapy and other medical intervention. OV9 number of victims. There were 2 to 9 placed in danger. OV17 10 points for driving recklessly, disregarding life. Your Honor, Mr. Foz thinks he's the victim here. You look at his information or the emails, excuse me, and this is what he says for the victim. To be bluntly honest with you, my opinion is the legal system is fucked. My honesty lands me in hot water. Menendez dishonesty lands him thousands in cash. That's fucked, really fucked. Your Honor, the only reason why he got a misdemeanor was because if it was an intentional act, we were concerned that his car insurance wouldn't pay for all the hospital bills and everything else that happened.
This exchange right here tells you everything about this defendant's mindset. When asked if he was disrespectful, he doesn't deny the behavior, he debates the definition. That's classic narcissistic deflection. Instead of saying, yes, I crossed a line, he reframes it as honesty, subjectivity, or justified outrage. And then, incredibly, he admits to telling court staff, you and the horse you rode in on. Let's be clear, courts don't care how angry you feel. They care how you behave. You can disagree respectfully. You cannot harass, insult, or intimidate people whose job it is to supervise you. The fact that he only concedes disrespect once the language is explicitly quoted shows that he doesn't believe rules apply unless he personally agrees with them. That's not misunderstanding, that's entitlement. And judges are especially allergic to that.
He got a gift of a misdemeanor where he needed to do community service to be done with this case. As you said, there's many non-physical activities that could be done. My suggestion, I remember at the hearing, was that he could go to a humane society and just sit and be around the animals to help, to help them essentially. Your Honor, if he had wanted to do community service, he could have done community service. He's been disrespectful to the court. He blames the court for everything. He blames the victims for his actions. I don't know what you should do, but I do know that he's a public safety risk because, as he said, he becomes irate, and it's due to his medical conditions. Something has to be done. I don't know what it is, and I'm going to leave it to you to make that decision.
All right, so this is sentencing on a number of probation violations. Initially, the concern was fail to complete 30 days of community service work, which was intended to be in lieu of jail time taking into account Mr. Fa's medical condition. And Mr. Faz was given the opportunity at the first probation violation. Well, it wasn't a probation violation hearing. We had a review hearing to determine how to go forward. And at that time, what I recall is Mr. Faz refused to provide any medical information of any substance so that I could even verify what his situation was and whether he was physically capable of doing community service work or not. He continued to give the probation department a hard time at every corner, even pursued them with FOIA requests asking for why his original probation officer, Ms. Hulse, left her position, FOIA requests to investigate them. And actually, my probation department, I think, protected me, or maybe Mr. Faz, I don't know, from the worst of the disparaging statements that he made about the court, about the probation agents, and Mr. Chamberlain hit on some of it. That's just the tip of the iceberg. Telling our probation agent, you need to back off and mind your manners, little miss. Thanks for really effing me in the back end.
Now the defense pivots hard into sympathy, terminal illness, chemotherapy, personality changes, military service, and these are serious, real issues. But here's the legal reality: mitigation only works when paired with accountability. The court already considered his health once, and that's why he avoided jail in the first place. What's frustrating the judge now is that every accommodation was met with resistance, hostility, or non-compliance, and pay attention to the revelation about alternative community service options like letter writing. Those weren't hypothetical, they were offered. The problem wasn't ability, it was attitude. Courts are flexible, but flexibility requires cooperation. You can't reject every solution and then claim the system failed you. That argument might work on YouTube comments, it doesn't work in sentencing. Clip 5. This is where the defendant completely exposes himself. He openly admits he becomes enraged when he doesn't get his way, and then tries to medically justify it. That's not mitigation, that's an admission of risk. From the court's perspective, he's essentially saying, I lose control, and I expect everyone else to manage that for me. But society doesn't work that way. Especially when your loss of control already resulted in someone being hospitalized. The judge isn't hearing remorse here, he's hearing rationalization. And when someone uses illness as a shield instead of a reason to be more careful, it raises red flags. Accountability matters more, not less, when public safety is involved.
You're nothing more than a bully with assumed powers, Mr. Faz, referring to his probation agent. You asked if I would sign a release of my medical records. I refused. You lose. I will give you the letter of disability, which you didn't ask for. If you can't tolerate someone challenging your supposed authority, become a librarian. Government employees are pieces of shit, ignorant, lazy, don't do their jobs. You know, I don't care what you say about me, but you're talking to someone who comes in every day, does her job, tries to do the best that she can. And Mr. Alhart said something about, I know people with cancer. Yeah, I've got a mother-in-law who has terminal cancer right now. I can't imagine her, with as much as she's gone through the last few years, ever behaving in the manner that you have. So, yeah, that's just the tip of the iceberg. I wasn't aware of all of the disparaging statements that were made. until reviewing for this case this morning.
Can you say something, Aaron?
No, it's my turn. The idea that the defendant was not able to complete community service work, as Mr. Chamberlain pointed out, is simply not true. He was given the opportunity because of his health condition to come up with ideas for how he would do that, including writing letters to veterans, including the suggestion of the Humane Society volunteer work that Mr. Chamberlain came up with himself, and continued to refuse to do that. He did complete 4 hours of community service work, I think at a thrift shop, maybe. So the defendant is asking to be continued on probation to complete community service, but we didn't even get into some of the threatening behavior that he engaged in. And it's a little too late. I agree with Mr. Chamberlain. I do view you as a public safety threat. In fact, we had an alert out to the courthouse because of your behavior, your threatening tone towards the clerks here, both at the prosecutor's office and the district court office.